Okay, let's go ahead and resume our discussion of the Louisiana Bar Examination's Criminal Law and Procedure exam. Yesterday at our last lecture we talked about substantive criminal law, which of course is 40 to 50% of the test. Today and in the next lecture we're going to talk about constitutional criminal procedure, which is usually 30% of the criminal law and procedure test. This, of course, is federal constitutional criminal procedure. It's usually tested on question 2, and question 2 usually is comprised of 6 subparts where you have to answer a hypothetical question about whether evidence should be suppressed. It's usually a gun or some drugs or a statement or a lineup identification. This is usually pretty straightforward stuff, most of it. Every now and again they'll throw you a curve, but by and large what is important here is the Fourth Amendment for search and seizure. That's out and away the most important aspect of what we're going to talk about because that's what's tested the most. And there it'll come up with a search of a house without a warrant or a search of a car without a warrant. And you have to talk about whether or not there is an exception to the warrant requirement that would apply and thus allow the evidence to come in rather than being suppressed. To a lesser extent, however, you'll be tested on Fifth Amendment and Sixth Amendment and 14th Amendment confession type issues, whether a confession is voluntary under the Fourth Amendment, whether it's been given after adequate Miranda warnings under the Fifth Amendment, or if it's been given in violation of the right to counsel under the Sixth Amendment. Those are the 2 big issues, and we're going to spend most of our time talking about those. Having said that, there are other issues that are sometimes tested. The most often tested other issue is lineups. When whether or not a lineup that was conducted in an unduly suggestive way should be suppressed. So we'll talk about that 14th Amendment, 6th Amendment lineup issues, and then spend the rest of the time talking about everything else. Things like double jeopardy is one that's tested, and every now and again the confrontation clause. So that's the plan, and off we go. Today we're going to talk entirely out of the Louisiana non-code book, and I don't have any mind maps for this. This is just the Barbry's National Outline for the topic. Well, it starts, page 1 here, with the introduction about which rights have been incorporated and made applicable to the states. You're not tested on that. I'm not going to talk about it. You spent time talking about that back in criminal procedure. Which one of these, which rights have been incorporated? Well, basically, all of the rights in the Bill of Rights except for the right to bail. As you'll see, Louisiana has a right to, under the statutory criminal procedure portions of Louisiana criminal procedure, you have a right to bail. Also, a right to indictment by grand jury. That hasn't been incorporated and made applicable against states, but everything else has. Turning to page 2, and there we go, right to indictment and prohibition against excessive bail. All right, let's start right in with the Fourth Amendment, because I'm glad that this is first in the national outline, because it's obviously the most important issue that's tested on the Louisiana bar. Fourth Amendment provides, of course, that people should be free from their persons, from unreasonable searches and seizures. That's the overarching standard. What's a search, and what are the issues? What's a search, what's a seizure, and what is reasonable? And that's what we will spend all of our time talking about. A search occurs when a governmental actor has intruded into an area where you have a reasonable expectation of privacy. More on that. A seizure occurs of a person when he's arrested, but also lesser seizures of people are recognized under the Fourth Amendment. Things can be seized as well. What's reasonable, of course, depends on the circumstances. The starting point for evaluating the reasonableness of governmental conduct is, of course, the warrant. Did the governmental actors have a warrant? Because usually that's what's required for a search or a seizure to be reasonable. If they don't have a warrant, it still may be reasonable if one of the exceptions to the warrant requirement applies. Much more on all of that to follow. Okay, first of all, seizures of the person. And what is a seizure of a person? When and why does it matter? Well, it matters because if you have been seized, then the government needs a justification for doing so that passes muster under the Fourth Amendment. All right, what constitutes a seizure of the person? First of all, obviously, if you are arrested, that is, if the police lay hands on you, put handcuffs on you, put you into police custody in the back of a car or in a jailhouse, obviously that is a seizure of the person. However, you can be seized under circumstances less onerous than arrest, and that's evaluated under a totality of the circumstances test. And that test is whether a reasonable person would feel that he is not free to leave. That's kind of one of those little buzz phrases that you really kind of need to put in your toolkit there for the bar. Whether under the totality of the circumstances a reasonable person would not feel free to leave. To constitute a seizure of the person, there must either be a physical application of force or a submission to the officer's show of force. If you are running from the police and the question becomes, have you been seized while you've been running? Well, no, because the police aren't physically applying force to you because you are not being touched by them and you are not submitting to the officer's show of force. Now, the Louisiana Constitution takes a slightly different view on this, which we'll take up more in our last lecture, but just keep in mind that that's the view under the U.S. Constitution. All right, and up at the top of page 3, the Kopp versus Texas case is discussed just to give you an example of whether or circumstances under which a person might be seized in circumstances less than arrest. All right, arrests. So you know when you're under arrest, you've got handcuffs on you, you're in the back of a car, you are in jail, those sorts of circumstances when you are in custody for purposes of prosecution or interrogation. Okay, since you have been seized by arrest, you have Fourth Amendment rights. Put another way, the police can't do that unless it's reasonable under the Fourth Amendment. What generally is required to make a seizure of the person through arrest reasonable under the Fourth Amendment? Well, the police have to have probable cause for your arrest. When do they have probable cause? When at the time of the arrest, the officer has within his or her knowledge reasonable, trustworthy facts and circumstances sufficient to warrant a reasonably prudent person to believe that a crime has been committed and the suspect has committed it. So that's you need to kind of have that little buzz clause in your pocket for the exam. Probable cause exists when a reasonably prudent person, based on the totality of the circumstances, believes that a crime has been committed and that this suspect has committed it. All right. An arrest is not invalid because the grounds stated for the arrest at the time it was made are erroneous, as long as there are other grounds that the police have for the arrest. Again, it's just in the totality of circumstances, everything known to law enforcement, if that is enough to rise to a level of probable cause, the probable cause exists. Now, we know that the Fourth Amendment requires probable cause for arrest. Does it require a warrant in order to be reasonable under the Fourth Amendment? The general rule is no. The police do not have to go off and get a warrant prior to arresting you if you are arrested in a public place. If they have probable cause to believe that you've committed a felony, and you're in a public place, they can arrest you without a warrant. As to misdemeanor arrest, an officer can arrest you without a warrant for a misdemeanor committed in the officer's presence. If the officer sees it or hears it. Home arrests, however, are different, and that's a theme that you'll see as we go through the Fourth Amendment. Homes, houses where people live are different. Police must have an arrest warrant to effect a non-emergency arrest of an individual in his or her own home. All warrantless searches of homes are presumed to be unreasonable. Now, what about if you're at your friend's house? Generally, if the police execute an arrest at your friend's home without obtaining a search warrant, the arrest is still going to be valid, but evidence of any crime found in the home can't be used against the owner of the home since it's the fruit of an unconstitutional search. And you'll see when we get to standing under the Louisiana Constitution, you could move to suppress that as well, even though you're not the homeowner. What's the effect of an invalid arrest? We know that an arrest requires probable cause, usually doesn't require a warrant, but sometimes it does if you are in your own home. Suppose the police get it wrong. They arrest you without probable cause or without a warrant when a warrant would otherwise be required. Well, the prosecution that follows is still going to be a valid prosecution. So it doesn't have any effect on a subsequent criminal prosecution. However, and this is why it's always litigated in pretrial motion practice, any evidence that the police obtain as a fruit of that unconstitutional seizure of your person is going to be suppressed. And usually what it is that it's a confession that you give after you've been unconstitutionally arrested. That can be suppressed as a fruit of your unconstitutional seizure of your person. Okay, so we know that an arrest is a seizure that requires compliance with the Fourth Amendment. What about detentions less than arrest? Well, you know, here there's this, when I teach constitutional criminal procedure, I've got a little slide that has an escalator on it. As your encounter with the police escalates, up at the top is arrest. That's as high as you can get with the police restricting your liberty. But as you kind of go down the escalator, where the police are restricting your liberty, but not to the extent of arrest, to what extent does the Fourth Amendment apply? Well, the lower that you get, the fewer Fourth Amendment rights you have. The Fourth Amendment is not a binary on-off thing. It requires different, or gives you different rights depending on how intrusive your encounter with the police is. The most intrusive is arrest. The least intrusive is if the policeman stops you in front of the law school and says, "What time is it?" And you say, "I killed 3 people." Well, you know, you had an encounter with a police officer. The question is were you in custody when you gave that confession? And the answer is no. The cop is just asking you the time. If the cop places you under arrest and then you confess, it might be different. It will be different, right? So that's what this is all about. What if he doesn't, the cop in front of the law school doesn't just ask you the time. Instead, he says, "What time is it?" You say, "It's 9:20. And then he starts putting his hands on you and squeezing your pockets and grabbing you all over the place, trying to feel you up. Well, that's different, right? That's more intrusive than him just asking you the time. And suppose he doesn't just ask you the time. He says, "Hey, what are you doing around here? Well, where you been this morning? What you got in your pocket? Well, don't leave, son." They always call you son, even though that's not your father. "Don't leave, son. Let me ask you some questions here." Well, now, you see, you're not under arrest, but you're not just being asked the time. You're somewhere up the escalator from being asked the time. And that is what we're talking about now, an investigatory detention where the cop stops you for more than just a transitory minute. Now, do they have authority to do that? They do. They can do that, but the Fourth Amendment gives you some rights. And that's what this is all about. Now, not full rights that you'd get under arrest if you were under arrest, but it gives you some rights. And the question is, what are they? Okay, so here we go. Police have the authority to briefly detain a person for investigative purposes, even if they lack probable cause for arrest. However, the Fourth Amendment requires something, and what it requires is that the policemen have at least reasonable suspicion based on articulable facts that you are somehow involved with criminal activity. Now, if he has reasonable suspicion based on articulable facts, then he can't arrest you, because he can only arrest you with probable cause, but he can hold you for more than just a second. He can make you sit there for a couple of minutes, 2, 3, 4, 5, 10 maybe, and he might be able to ratchet it up a little bit higher and start frisking you if he believes that you have weapons of assault, knives, guns, those sorts of things. So now keep in mind that the Supreme Court, when it decided Terry versus Ohio back in 1968, could have gone in two directions. Number one, it could have said it's binary. Any custody requires probable cause. Any stop requires probable cause. Or they could have said, if it's not arrest, nothing's required. This was really just kind of a middle ground. Something is required, not full probable cause, just reasonable suspicion based on articulable facts. So what does that mean? Well, if the cop stops you in the front, he can say, hey, stop, don't leave. I want to ask you some questions because you look a little rough and suspicious to me. I got a hunch in my gut. Well, that's not enough. He can't stop you. You can keep walking. Why? Because he doesn't have reasonable suspicion based on articulable facts. Facts to be articulable must be able to be counted on one's fingers. You were running. You were looking around furtively. You had a canvas bag with a dollar sign on the side. You had a bandit mask on. Well, that all starts making you look more suspicious, and you can count those on your fingers. So those are reasonable. He does have a reasonable suspicion based on articulable facts, not just some inarticulate hunch. Okay, again, court hasn't defined reasonable suspicion. Requires something more than a vague suspicion, but full probable cause is not required. It's viewed under the totality of the circumstances. Source of suspicion, again, like probable cause, reasonable suspicion doesn't have to arise from a police officer's personal knowledge. Again, it's based on all the totality of circumstances. If stuff coming over the radio, hearsay coming over the radio. It could be from an informant's tip. For example, somebody could run up to the officer, and that would be an informant, and point to you across the street and say, hey, that person just robbed a bank. Well, is that going to be enough to give the officer reasonable suspicion? Well, maybe. Again, depends on the totality of the circumstances. Are you running, looking furtively? Again, totality of the circumstances. If it's just an informant's tip, though, generally you have to have more indicia of reliability than just that. Somebody just calls 911 and says you're a dope dealer. Is that enough for reasonable suspicion? Probably not. But again, on the next page, it just gives you some cases that shed some light on this. It's all just a matter of totality of the circumstances. And, for purposes of you in the bar, all you have to know is, again, totality of the circumstances, articulable facts, and say reasonable suspicion exists, and then show the examiner the facts that you can count on your fingers that lead to reasonable suspicion. How long, okay, so if the cop does have reasonable suspicion based on articulable facts, how long can he hold you? Well, here it just depends. Like everything else, it seems. It just depends on what he's doing. He can keep you for as long as necessary to confirm or dispel the reasonable suspicions. Again, it really can't be more than 5, 10, 15 minutes usually. Again, it all turns on on the totality of the circumstances. If the cop keeps you too long, it then starts looking like an arrest, or the functional equivalent of arrest, and then they're going to need probable cause to hold you. Can the cop ask you for ID? Yes, as long as the cop can stop you. He has reasonable suspicion to stop you. He can require that you identify yourself and present ID. If he develops probable cause during this investigatory stop, like for example he sees a gun on you or something, then it ratchets it up to he's got probable cause, now he can arrest you. What constitutes a stop? This is the cop asking you for the time, right? If he merely approaches you and doesn't detain you, that's neither an arrest or an investigatory detention, which means that the cop doesn't need any Fourth Amendment justification. He doesn't need either probable cause or reasonable suspicion. Property seizures on reasonable suspicion, just like the cop can seize you for a brief time with reasonable suspicion, he can seize your stuff for a short period of time, again, just long enough to dispel any suspicion he might have. Okay, so what have we just talked about? Remember what we're talking about. We're talking about seizures of the person, arrests and other detentions, right? We're in B. We talked about what constitutes a seizure of person. We talked about arrests. We talked about other detentions, investigatory detentions, stopping you on the street. What about an investigatory stop of your automobile? You're driving along and the police officer pulls up beside you at the stoplight and you've got a stocking mask on your head. Well, he doesn't have probable cause that you've committed a crime. He doesn't even know a crime has been committed. But guy driving around with a stocking on his head, can he stop you now and ask you some further questions? So that's what this is all about. If you stop a car, if he puts on his lights and makes you pull over, that is a seizure of your person. And it needs to be justified either by probable cause or by reasonable suspicion, depending on how long he keeps you, right? So that's the general rule. However, if the cop stops you because there's some special law enforcement need connected to the automobile and its mobility, like for example, it's a DWI checkpoint, or they're looking for the lost little girl, that's another kind of checkpoint that they could have, then cops can stop automobiles or people if they set up a people checkpoint without reasonable suspicion or probable cause, assuming that these stops really are targeted at some non-investigatory reason. They're trying to protect the roads or find the little girl. So that's the special law enforcement need. These roadblocks must be based on some neutral articulable standard, every car, every other car, and be designed to serve purposes closely related to a particular problem pertaining to automobiles and their mobility. So, for example, the police, without probable cause or reasonable suspicion, can stop cars at a checkpoint if they're looking for drunk drivers. Again, there needs to be some neutral articulable standard, every car, every other car, but they can do it because that is related to a problem that pertains to automobiles. They cannot, however, and this is the Indianapolis versus Edmond case, they can't just set up a general dragnet stop looking for crooks, right? They can't, even if they're setting it outside of a known crack distribution neighborhood, they can't set these up to catch a crook. And that is really the simplest way to look at what kinds of roadblocks are okay, which sorts of roadblocks are permitted and which are not. If they're setting it up to catch a crook for general law enforcement, they can't do that. They need either probable cause or reasonable suspicion to stop you. If they're doing it for something other than to catch a crook, like to prevent drunk driving accidents or to find the little girl who's missing, that's different. Okay, an automobile stop, once the cops pull the car over, they have essentially seized everybody in the car, not just the driver. So, for example, if they pull over the driver because they think he looks suspicious, and when they do it, the passenger confesses, well, the passenger's been seized for no reason, right? Without reasonable suspicion, that could be suppressed as well. Distinguish informational roadblocks, and that we've already talked about there, that if they're stopping everybody looking for the missing little girl, then that is not an investigatory stop, it's an informational one. If the police stop a car, the police can essentially protect themselves by ordering everybody out of the vehicle. Pretextual stops. This has always bothered me for some reason, but this is the law. Suppose the cop pulls up on side of you and you don't have a stocking mask on, but he just thinks you look a little fishy. So he follows you for a block or two and then sees that you didn't use your blinker in changing lanes. So he pulls you over. Well, the reason he's pulling you over is because he thinks you look fishy. But he says he's pulling you over because you didn't use your blinker. Is that okay? Yes, that's okay under Wren versus the United States. Why? Because as long as he has probable cause or reasonable suspicion to pull you over, then the stop is going to be okay under the Fourth Amendment, even though he's really pulling you over because you look fishy. Detention to obtain a warrant. If they think you got drugs hidden in your house, they can prohibit you from going in the house. So again, it's all just a matter of a detention to prevent you from destroying evidence. In order to be, that brief detention has got to be reasonable, so it can't go any longer than necessary to get the warrant. It's all about reasonableness. Likewise, when the police are in the house making a search, they can detain you while they're searching so you don't go destroy evidence. To take you to the station house for questioning, they need full probable cause because that's like an arrest. If you get subpoenaed to go to a grand jury to testify, that's not a seizure of your person. Deadly force. If the cops shoot you, the bullet runs out and grabs you and throws you to the ground. So that is a seizure. And that must be justified by the Fourth Amendment. So the cops just can't shoot you. They can only shoot you if they have probable cause to believe that you are a danger to them or to the public. Okay, we've just talked about seizing people. Let's now talk about seizing evidence. Like seizures of people, seizures of evidence must be reasonable under the Fourth Amendment. And usually to be reasonable, evidence must be seized pursuant to a validly issued warrant, unless one of the exceptions to the warrant requirement applies. Okay. So what's the general approach to analyzing Fourth Amendment seizures of evidence? Well, the first issue you've got to address is whether or not the Fourth Amendment even applies. So suppose you're walking out in front of the law school and you're carrying a big 3-gallon pot with a marijuana plant. Cop comes up and sees the marijuana plant, and then he seizes it from you. Well, is the Fourth Amendment even implicated by that? And that's the first question. And it is, at least the first branch of it applies here because we're dealing with a governmental actor. It's a cop in my hypothetical. So first of all, the Fourth Amendment only applies to cops. It doesn't apply to mall cops. Mall cops think they're cops, but they're not. They're mall cops. And they are not governmental actors. So you don't have any Fourth Amendment rights with regard to their activities. The next issue that you need to consider is whether or not you had a reasonable expectation of privacy. More on that in a second. Then, if the Fourth Amendment applies, the next question is did the police have a valid warrant? And if they did not, was the warrantless search otherwise permissible? Okay, governmental conduct. I've never, well, maybe this was tested once. Well, no, it's been tested more than that now that I'm thinking about it. The Fourth Amendment generally only protects against governmental conduct and not against searches by private persons. The way this pops up in the bar is that suppose you're working at Best Buy and your manager rifles through your locker and finds some dope and calls the police and gives them the dope. Question. Did the Fourth Amendment apply? Did you have a right to have a warrant issued and require that probable cause exists prior to the search of your locker? Well, the answer is no. Under those circumstances, your manager did it. He's not a cop. But if the police show up at Best Buy and they say to your manager, open that locker, we want to see if your employee has any dope, and he does, well, now we've got some governmental conduct, even though your manager opens it, just like he did in my first typo, but he's doing so at the direction of governmental actors. There, we have governmental state action, and the Fourth Amendment potentially applies. Okay, that's the first thing. Next, we need some intrusion into a constitutionally protected area or a violation of a reasonable expectation of privacy. Now, again, this law is still developing. The Jones case from 2012 is a recent case that kind of set up this disjunctive either-or approach to when the Fourth Amendment applies. It applies when there's a physical intrusion into a constitutionally protected area or a violation of a reasonable expectation of privacy. So, for example, and again, we're going to get into more details as we go, but if the police stick a GPS, magnetic type GPS tracking device to your car and use it to monitor your movements around town, that's a physical intrusion into a constitutionally protected area. They trespassed onto your personal property, your car, to put that magnetic beeper on it, and that was the Fourth Amendment gave you rights. They needed to either have a warrant or probable cause or both in order to do that. So there we had a physical intrusion. Now, standing, I want you to scratch out that whole A. We're going to deal with standing when we discuss the Louisiana Constitution, because the Louisiana Constitution gives virtually everyone standing, so just scratch through all that standing stuff. And now let's talk about things or areas where you don't have, or you might have a reasonable expectation of privacy. And think about it like this. I mean, when you're walking around your house in your boxer shorts and T-shirt, you have a reasonable expectation of privacy, right? That's why you're walking around in your boxer shorts and your T-shirt. You're not thinking anybody's looking at you. You wouldn't go out and wear the boxer short and T-shirt in a mall because it's not a private place. So think of that when you're thinking about whether you have a reasonable expectation of privacy in a place. And then let's look out at things held out to the public. You don't have a reasonable expectation of privacy in objects held out to the public, like the sound of your voice, like your handwriting, like the paint on the outside of your car, the smell of the luggage that you're holding in your hands. Why? Because everybody can see that or smell that. Right? If you're walking down the street and a cop comes up and smells marijuana in your duffel bag, well, I mean, you have no expectation that the smell would be private because you're walking around with it, just like he could see you in your boxer shorts as you're walking around. Now, what about Suppose you put in your duffel bag, your little backpack, let's just use your book backpack, you put in there let's say you put in there, well, just stick with the marijuana, a brick of cocaine, let's say, and you zip it up and you start walking. Well, are you trying to keep that out of view? Of course you are. You don't want to go to jail, so you're walking around and you expect that your backpack is a private thing. I mean, nobody can see what's inside on the streets, right? So you think it's a private place. Well, and it is. But suppose a cop comes up and says, what you got in that backpack? And you keep walking. You say, I don't want to talk to you, officer. You keep walking, and he's following behind you and talking to you. And he's saying, where are you going, son? And you saying, I'm not talking to you, officer. So far, so good, right? You're not detained. Then what he does is he reaches his hands out and he starts squeezing your backpack. And he goes, what's this brick-like powder compressed stuff, son? And then the question becomes, did he need a warrant to do what he did? And the answer is yes. You do have a reasonable expectation that nobody's going to walk up and start squeezing your bag, right? I mean, if I walked up and started squeezing your bag, you'd say, what the hell are you doing squeezing my bag? It's my bag. Don't squeeze it. So you do have a reasonable expectation of privacy in that regard, which means you have Fourth Amendment rights. If a governmental actor comes up and starts squeezing your bag, he needs, generally, a warrant to do that. Dog sniffs at traffic stops. Suppose your car stopped at a lawful traffic stop. It's lawful either because the cop has probable cause or reasonable suspicion, or because it's a DWI checkpoint and it's a lawful stop. But while they're stopping you, asking you for your driver's license and everything, they got the little dog walking around your car sniffing it. And then all of a sudden he alerts on your trunk. Well, what about that? Well, do you have put another way, do you have a reasonable expectation of privacy with regard to the smells emanating from your car, from your person, from your backpack? And the answer is no, you don't. Dog sniffs at the entry to your home. And again, here we've got developing case law, and this is Florida versus Jardines from just last year. Although the entry to a home is within the curtilage protected by the Fourth Amendment against unreasonable searches, more on that in just a second, a police officer may approach a home in hopes of speaking to its occupants just like a private citizen, such as a neighbor or delivery person. That is, you know, people can walk up and ring your doorbell, and if you answer the door, that's fine. You know, you expect that sort of stuff. However, the scope of that license you give people to come up to your front porch and to ring your doorbell is limited. Police officers may not exceed the license by having a drug dog sniff around the entry or other areas within your curtilage. Such a physical intrusion, and this is where the case where this language came from, such a physical intrusion into a constitutionally protected area constitutes a search within the meaning of the Fourth Amendment and therefore requires a warrant or an exception to the warrant requirement. And in Jardines, a dog alerted at the defendant's front door, that could not be used as a basis of probable cause to get a search warrant. The sniff was an unconstitutional warrantless search. And think about it, right? You give people generally the right to come up and ring your doorbell to see if you're home, to deliver a UPS package, but you don't give people the right to come up and to your front porch and press their face up against your window and look in, right? That's not why you let people on your porch. And that's what that case is all about. All right, open fields. Do you have any reasonable expectation of privacy as to areas outside of the curtilage of your house? The curtilage is the area right around your house, behind a fence usually, right? The answer is no, because if you've got a large backyard that's not fenced in, then even though you may have posted signs, no trespassing signs, that still is not going to be enough to give you a reasonable expectation that it's private back there. You wouldn't go walk around back there in your boxers. Flyovers. You don't have any reasonable expectation that police won't fly over and look in your backyard. And so you would be worried, and should be worried, about having marijuana growing in your backyard, even if it is within the curtilage. Police can fly over, anybody can fly over and look in. Now, what about technologically enhanced searches? And this is the Kylo case, which is, God, it's so old now, I can't even believe it's 2001. But in that case, all the police did was point a thermal imager at the house and saw that there were grow lights going on, being used inside, and used that as a basis for getting a warrant to search the house. Well, the court there said that that was an unlawful intrusion, that the Fourth Amendment, you have a Fourth Amendment reasonable expectation of privacy, that people aren't going to be pointing imagers, thermal imagers at your house and seeing you walking around from the bathroom to now that's at least when the technology is not in general public use, goes too far. Okay, searches conducted pursuant to a warrant. What we've talked about now, and again, remember, we're talking about the Fourth Amendment. We've just talked about the Fourth Amendment only applies when a governmental actor physically intrudes into a constitutionally protected area, or looks into or comes into an area where you have a reasonable expectation of privacy. Assuming that has happened, then the Fourth Amendment kicks in. And once the Fourth Amendment kicks in, you have a right to what? Well, that's where we go into. That's what we go into now. First of all, you generally have a right to have that search conducted pursuant to a warrant, unless an exception to the warrant requirement applies. So we'll take our break now for about 8 or 9 minutes, and when we come back at the top of the hour, we are going to start talking about searches conducted pursuant to warrants. Okay, let's resume. As we left off, we were discussing searches, or getting ready to discuss searches conducted with a warrant. Now, of course, that's the preference, that all searches be conducted pursuant to a valid search warrant. But there are exceptions, which we'll get to in just a second. But for now, let's talk about when the police officers do it perfectly by the book. And by the book, I mean by the Fourth Amendment book. That is, they go and get a warrant. This is what, of course, it says to be reasonable in the Fourth Amendment. Most searches have to be conducted pursuant to a warrant, and this just requires police to go explain themselves to a neutral and detached magistrate before they go invade someone's privacy, and that's basically what the requirements are, or why the requirement exists. What are the requirements for a valid warrant? First of all, it's got to be issued by a neutral and detached magistrate. Another good buzz term for you there. Based on probable cause. We've already talked about what probable cause is. And the warrant must meet the particularity requirement, which means that it must particularly describe the place to be searched and the things to be seized. Okay, probable cause. Well, we've already talked about what probable cause is once. Here we go. We're going to talk about it again. The magistrate, neutral and detached magistrate, has got to independently evaluate whether from the totality of circumstances presented to him or her, whether or not a crime has been committed and the place to be searched is going to have evidence of that crime. Can be anticipatory, that is, the warrant can be to search your house tomorrow because it's believed that a drug delivery is going to happen there tomorrow, for example. What about informants? Suppose an informant calls 911 and says that you have bales of marijuana in your living room. Is that enough? Well, not if it's just that, probably, but again, it's just a totality of the circumstances test. You can consider things like the informant's track record, whether the informant has given lots of detail that has been corroborated by the police through other investigation. Again, it's just a totality of the circumstances. There's no per se rule that excludes from a probable cause consideration tips from informants. Now, going behind the face of the affidavit. Now, I don't know why this is under use of informers. This really should be a 3 rather than a 2C. But what's this all about? And this has been tested before. Of course, when the police officers go to the magistrate's chambers, what they have is an affidavit in which they've said under oath, we saw the defendant go into his house with a bale of what appeared to be marijuana on his shoulder. An informant told us that he was a marijuana dealer. We smelled marijuana near his house from the sidewalk, period. Okay, those are the 3 statements of fact in the affidavit. The magistrate looks at it and says, wow, in the totality of the circumstances, I think there is probable cause to believe that this guy has marijuana in his living room and that it will be found when his house is searched. Therefore, the magistrate issues the warrant. Well, what if the cops lied in the affidavit? Suppose they never smelled any marijuana from the street, they just made it up. That's the issue. When the defendant attacks the validity of a search warrant, the Fourth Amendment permits her to contest the validity of some of the assertions in the affidavit upon which the warrant was issued. This is called going behind the face of the affidavit, because on the face of the affidavit, there is probable cause to issue a warrant and then to search the house. So how can you succeed in getting the warrant invalidated because of the lies in the warrant affidavit? That's what this is all about. Now, uphill battle, hard to prove this. Why? Because, well, first of all, you have to show all 3 of these things. Number one, that there was a false statement in the affidavit. Well, we got that. Just assume with me that the cops never smelled anything. Two, the affiant, here the cops, intentionally or recklessly included the false statement. They sure did that. They did it intentionally. They hate this guy, so they made up that fact. Well, you think that would be enough, right? Because a warrant was issued in part based on that intentionally false statement in the warrant affidavit. But there's a third requirement, which is the false statement was material to the finding of probable cause. How do you determine if a statement was material to the finding of probable cause? Well, what you do is you take a black marks a lot on the affidavit. I mean, you do this metaphorically. And you scratch out that false statement and you see what's left. Is what's left enough to be probable cause to issue a warrant? Well, what do we have here? What's left here? Well, informant says he's a dope dealer and the police saw him carry a bale of marijuana into his house. Those two statements are enough, alone enough for probable cause. Therefore, even though we have a false statement, it was not material to the issuance of the warrant. Therefore, you lose in your facial challenge to the warrant. And those facial challenges are sometimes called Frank's challenges, or they're evaluated at Frank's hearings after Franks versus Delaware, the 1978 case that gave defendants this ability to go behind the face of the warrant, but again made it a very tough standard for them to satisfy. The particularity requirement, okay, to be valid, a warrant, first of all, has got to be based on probable cause. Just talked about that. Second, it's got to list with particularity the place to be searched and the things to be seized. Why? We just don't want to give police roving commissions to go up and down the neighborhood searching all houses, right? Suppose the police saw you go into a gated community with a bale of marijuana on your shoulder. Can they go to the magistrate and say, give us a warrant to search all the houses in the gated community? No. That's a roving commission to go searching about town looking for evidence. It's got to list with particularity the place to be searched and the things to be seized. Search of third-party premises is permissible, and of course, I mean, search of anywhere is permissible as long as there's probable cause to believe that there's going to be evidence found in that place. Neutral and detached magistrate. The magistrate has got to be a true member of the judiciary branch, sitting back at the courthouse. Not necessarily. They could set him up in a trailer at a vehicle stop, for example. That's happened. But he can't be too buddy-buddy with the police. He's got to be neutral and detached. Police can't just keep him in the back of the cop car and ride around with him and get him to issue them warrants whenever they want the warrants. He's not neutral and detached under those circumstances. He can't get his pay based on warrants being issued, because then he'd have an interest in issuing warrants. So, got to be neutral and detached. Okay, so the warrant's got to issue on probable cause. It's got to come from a neutral and detached magistrate, and it has got to describe with particularity the place to be searched and the things to be seized. What about when the police go and execute the warrant? So not only must for a search to be reasonable under the Fourth Amendment, usually they need a warrant, valid warrant for all the reasons, we just discussed, but also when the police are carrying out the search, they've got to act in a reasonable manner. So if they come into the house and they're searching for an elephant, can they take an axe and bust open all of the drawers and closets of the house? Well, no, that would be unreasonable under the circumstances, and that would violate the person's Fourth Amendment rights. So, what are the requirements or the things that police must do to make the execution of a warrant reasonable? Well, first of all, it's got to be executed by police. Police can't go get a warrant and then just hire it out, the execution out. It's got to be by the police. It's got to be executed without unreasonable delay, otherwise it becomes stale. So if the police have probable cause to believe that you have marijuana in your house and they get a warrant to search it, today. They can't come back in a month and search it. That would be unreasonable. They have to knock and announce, which is they're standing out in front with a warrant. They've got to knock and say that they're the police, and then they, after they knock and announce, they have to go in. Now, then they can go in. Are there times when the Fourth Amendment says that it's reasonable to enter without a knock and announce? Yes, if there's going to be a destruction of evidence inside. They don't want to knock and announce that they're coming. Knock and we're police, go ahead and start flushing all your dope. No, they can go in without a knock and announce, and because it's reasonable under those circumstances. Well, now the question becomes, what's the remedy? Suppose the police are executing a warrant at your house because you are believed to have stolen an elephant from the zoo. So you're not going to be able to flush that elephant. So they have to knock and announce. But suppose they don't knock and announce. They just come to your house and they bust in with, of course, all their SWAT gear and all, and they find the elephant in the room. There he is, in the living room. And they seize the elephant and they lead him out and all. Is that can you suppress the elephant now because they seized the elephant pursuant to an unreasonable execution of a search warrant? Well, the answer is no. We'll talk more about it when we get to VB8. But the short answer is no. The remedy for a knock and announce violation, and there was a violation, is not suppression of evidence for reasons we'll talk about when we get there. Okay, also to be reasonable, the execution of the warrant has got to be one that is reasonable in scope. If the police are looking for an elephant, they can only look in places where an elephant may be found. They can't look in your jewelry box. Seizure of unspecified property. Suppose that they are the warrant lists with particularity the thing to be seized, namely one circus elephant or one zoo elephant. And they see, while they're searching for the elephant, in plain view, a bale of marijuana on your living room, coffee table. Can they seize it? Well, yes, it's in plain view. For reasons we'll talk about, they can seize it, even though it's not listed with particularity. Search of persons found on the premises. They generally cannot search you, but if they have probable cause to arrest you, then they can search you incident to arrest. More on that in just a second. They can also always do a search for their own, a quick pat down for the officer safety. We've already talked about how if they're executing a warrant, they can briefly detain the occupants while they're doing that. That's not an unreasonable search or seizure of the occupant's persons. All right. Now we get to the most important topic that we'll talk about in our whole discussion of criminal procedure, which is going to take place over 2 lectures, 6 hours. This is what is going to account for the plurality of questions that you'll get relating to constitutional criminal procedure. So this is important. And what is it? Exceptions to the warrant requirement. That is, when the police may search a place without a warrant. Generally, to be reasonable, a search has got to be conducted with a warrant. But when can the police search without? And that's what this is all about. There are here discussed 6 exceptions to the warrant requirement when the police can search without a warrant. Okay. Which ones will you see? Well, you'll probably see at least 2 of them on the bar. One of which very well may be a search incident to lawful arrest. SILA, S-I-L-A, search incident to lawful arrest. So, remember, of course, if you are under arrest, the police have probable cause to believe that you have committed a crime. Otherwise, they couldn't have arrested you. So now that you're under arrest, the question is can they dig in your pockets? Can they dig in the suitcase you were holding at the time of your arrest? And that's what this is all about. As long as you are actually arrested, they can search your person and your grabbing area. By grabbing area, I mean any place where you might be able to grab a weapon or evidence. What if they can arrest you, but they don't arrest you? They just issue a citation. Because if a police officer pulls you over for running a red light, he can arrest you if he wants, but usually they just issue you a citation. So if he just issues you a citation, can he still search you and maybe your car incident to your arrest? No. It's search incident to lawful arrest, not search incident to lawful coulda arrested. The geographic scope of this search is, again, just we've said, the grabbing area, wingspan is another way to describe it. It's the person and the grabbing area or wingspan of the arrestee. Now, police can also make a protective sweep of the area beyond the wingspan if they believe that accomplices may be present. What about the search incident to lawful arrest of an automobile? Suppose you're arrested when you're driving your automobile. Can they then, we know that they can search you and your grabbing area, but can they search your car? Well, the short answer to that is no, not if it's no longer in your grabbing area. If they have, the police have put you in handcuffs in the back seat of their cruiser, can they search the car incident to that lawful arrest? And that's what this is all about. If you're unsecured and still can grab something in the interior of the vehicle, then they can search it. If they believe that evidence of the offense for which you are arrested can be found in the vehicle, they can go look for that evidence. So what does that mean? Suppose that you're arrested because they have probable cause to believe that you are smuggling dope. They arrest you because they have probable cause. They get you out of the car, they put you in handcuffs, they put you in the back of the police cruiser. Can you grab anything in the passenger compartment? No. So they can't search the passenger compartment pursuant to that exception, the grabbing area exception, but they do believe that you are a drug smuggler and you have dope. So they can search the car for the evidence for that they believe that they have probable cause to believe is in the car. Now the rule used to be that they could search the whole car, but that's all dead. That's the rule right there at the top of page 19. No need to get into the history of these sorts of things anymore. Search incident to lawful arrest must be contemporaneous in time and place with the arrest. What's contemporaneous for an automobile? Again, we mean roughly contemporaneous, not simultaneous. The Thornton case there discussed at the top of page 20 talks about how even if he was a recent occupant of the automobile and they have evidence, probable cause that there's evidence of the crime in the car, then it can be roughly contemporaneous. If they arrest you, they can search your personal belongings. And of course, they could always do an inventory search of an impounded car or impounded property. Okay, so that's the first exception. Search incident to lawful arrest. And remember, all those things, it's got to be a search incident to arrest. That means it can't happen long after. It's got to be incident. It's got to be a lawful arrest. If the arrest is without probable cause, then this exception doesn't apply. And it's got to be an arrest, not a coulda arrest. So just remember each one of those elements. They're right there in the title of the exception. Search incident to lawful arrest. Automobile exception. This will be on the test. This will be. It just will be. And it couldn't really be easier. And what's the whole automobile exception? Well, here it is. If the police have probable cause to believe that there is evidence of a crime in the car, they can search it without a warrant. That's it. So the police get a tip that you have a bale of marijuana in your trunk. The police corroborate the tip by getting some additional evidence that you were seen carrying a bale earlier in the day. Okay, well now the totality of the circumstances starts looking like they have probable cause. So what can they do? They can just pull up behind you, pull you over. They can arrest you because they have probable cause to believe that you're smuggling dope. And they can also search your whole car pursuant to the automobile exception, even though they don't have a warrant. What's the scope of the search? Back up here on the top of page 21. If they have probable cause to search a vehicle, they can search the entire vehicle, passenger compartment, trunk, all containers in the vehicle, as long as the containers might contain the object for which they have probable cause. Like if they think you've stolen an elephant and you're riding around in a Ryder truck, they can search the back of the truck, but they can't search the passenger compartment and the glove box, for example. Search can extend to everything in the car where they have probable cause, belongings and purses of occupants, for example. What about containers placed in the vehicle? This is kind of a goofy thing. If the police only have probable cause to search a container recently placed in a vehicle, they can search that container, but the search can't extend to other parts of the car because they don't have any probable cause to believe that they're going to find any evidence. So again, this is just an extension of that. Motorhomes. Is the motorhome more of a home or more of a motor vehicle? If it's a Winnebago that is fully mobile, even though somebody lives in it, you treat it like a car. If it's a Winnebago that is up on cinder blocks and that is immobile, you treat it like a house. That's all there is to that. The automobile exception is not going to apply if it's an immobile automobile or motorhome. Contemporaneousness is not required. They can tow the car to the station and do the search there. Okay, so that's the second exception to the warrant requirement, and one about which you will be examined, no doubt. Plain view exception. Now, this is fairly simple. All this is that if the cop is in a place where he has a right to be, even if he doesn't have a warrant, he can bend over and pick up something that's obviously evidence and seize it. So this is really an exception to the warrant requirement for seizures. That's why it doesn't really fit here as an exception to a search warrant requirement. All this does is, like I said, if the cop is in a place where he has a right to be, like in your house, if he's got a warrant to search your house for that stolen elephant, he can bend over and pick up the bale of marijuana. He can seize it, even though he doesn't have a warrant to seize it. If you're walking on the street and you've got a marijuana cigarette in your hand, he doesn't have a warrant to seize it, but he can reach out and take it. Why? Because it's obviously contraband. So that's what this is. As long as the officer is legitimately on the premises, or more broadly, in a place where he has a right to be, and he discovers evidence or contraband, and that is in plain view, and it's immediately apparent to him that it is evidence or contraband, then he can pick it up and seize it. It's really that simple. Now, the Hicks case, there the officers are searching a house, and they have a right to be in there because they thought there was a shooting, so they had a right to be in the house. And while they're in there, they're going, wow, look at that stereo. That sure looks expensive. That must be stolen. We think it's stolen. We have a hunch that it's stolen. So what they do is they move the stereo, and they look behind it, and they write down the serial numbers, and then they found out it was stolen. Well, that was not a plain view seizure. Why? Because they had to manipulate and move it around in order to see it. Next exception to the warrant requirement, consent. This one is often tested. And you know, not only is it often tested, but it's in real life, the most prevalently used means for searching cars and houses. Police just knock on the door and say, can we come look in your house? And people say, yeah, sure, come on in. People get pulled over and the cop says, you mind if we look in your car? And people say, yeah, sure, go ahead and search the trunk. And they open the trunk and then a body covered in cocaine rolls out. You know, you wonder sometimes how stupid people can be. Why do they consent when they know that there's a body with cocaine all over it in the trunk? But they do. They do all the time. So this is what we are talking about here. The police can conduct a valid warrantless search if they have voluntary consent to do so. So the question becomes, what is required for consent? Do the police have to essentially Mirandize you? You know, you don't have to give us consent, but you can. Do they have to do all that? No, they don't have to do all that. So, again, the voluntariness is determined from a totality of the circumstances. Knowledge of the right to refuse is just one factor, not a prerequisite to a consent search. If the officers lie and they say, look, we got a warrant, but why don't you just let us in anyway? Well, that's going to negate the possibility of consent under that Bumper versus North Carolina case. Now, this comes up often, is who has the authority to consent? Who has the authority to consent? This is fairly often tested. And under what circumstances? Well, suppose the police come to your apartment and your roommate's home, but you're not. And they say, hey, is your roommate home? And, no, he's at the bar review class. Well, you mind if we look around? We think he might have some dope in here. And your roommate says, okay. That's a question. Suppose you're home and the police ring the doorbell, your roommate's at the door, you hear some talking, you walk up and you say, what are you doing, roommate? He goes, oh, I'm talking to the police, they want to come search for dope. And I've said they can. And you say, no, you can't come in here. No. Well, can they come? Because they've gotten consent from one roommate. So those are the issues, and that's what comes up on the bar. Okay. Any person with apparent equal right to use or occupy, now apparent, doesn't have to be actual, apparent equal right to use or occupy the property may consent to a search, and whatever evidence the cops find can be used against the other owners or occupants. And as I've just said, the search is valid even if it turns out that the person who gave the consent didn't really have the authority to consent. It's all about the way it appears to a reasonable officer. Now there is a limitation, and this is Georgia versus Randolph. The police cannot act on consent from an occupant if a co-occupant is present and objects to the search, and the search is directed against that co-occupant. So if you're home and you say no, under those circumstances, that consent from your roommate is not going to be valid. What about parents and children? Again, generally, a parent generally has authority to consent to a search of a child's room as long as the parent has access to the room. And again, it all turns on whether it appears to the officer that the person giving the consent, whether it's a parent or a roommate, has authority to allow people into that space. Now, if the police are being let into a common area like a living room or a kitchen or a dining room, it's going to almost always be reasonable for the officers to think that the co-occupant has the right to let somebody into that room. But suppose it's a locked bedroom. You got your bedroom, your roommate's got her bedroom. So can she let somebody into your bedroom? Well, the door's always closed. Even if you don't have a lock and key on it, she understands that she's not to go in there, and you understand you don't go into her room. Well, then if it would appear to the officers from when they're, if she says, well, that's his bedroom, I'll never go in there, but y'all can go in there. Well, under those circumstances, it would not appear to a reasonable officer that she has authority to consent to the search of that area. What's the scope of the search? Well, the scope of the consensual search is defined by the scope of the consent given. So, for example, suppose you get pulled over in your car and the police say, you mind if we search your car? And you say, no, you can search everything but the trunk. Don't open the trunk. Okay? Well, if the police open the trunk, then under those circumstances, they have violated the scope of the consent that you've given. They can search everywhere else, but not the trunk. Stop and frisk. We've already talked about this, but this is, here we go talking about it again. We've already talked about the stop, right? Police need at least reasonable suspicion to stop you because it is an intrusion on your interest in liberty, and therefore the Fourth Amendment requires something, not full probable cause, but it requires reasonable suspicion. But now let's talk about the kind of the search aspect of it, when they can just start putting their hands on you and feeling you and stuff. They can do that if they reasonably believe that you're armed and presently dangerous and armed with weapons of assault. What's the scope? They can pat down your, next page, they can pat down your outer clothing. Again, what they're looking for are weapons of assault. They can also essentially pat down automobiles. If they pull you over an automobile, they can kind of quickly look for weapons of assault, even if they don't have probable cause to believe that the car contains evidence. They can, if they've got, they can look in the door pockets and whatnot, looking for weapons of assault. They can ask you for ID, which we've already talked about. Okay, now suppose that we've already talked about all of that, but we just talked about it again. New issue. Suppose while the cops are patting you down for weapons of assault, the cop finds a marijuana joint. Can he seize that now? Well, he wasn't looking for that. He couldn't look for that, but he finds it. Well, that all turns on whether or not it was obvious on plain feel that what the officer touched was evidence or contraband. He can't kind of manipulate it and say, it rolls, it's a little crunchy, it feels a little bit like a marijuana. It is a marijuana cigarette, he pulls it out. That's too much manipulation. He knows that it's not a gun or a knife, but while he's quickly patted down, he goes, oh man, that's a joint. Then he can seize it. So that's what this is. If the police officer conducts a pat-down within the bounds of Terry, he may reach into the suspect's clothing and seize any item that he believes, based on plain feel, is weapon or contraband. Okay. Exigency. No need for a warrant if there is an emergency. That's really almost could sum up all of these, this next page, right? They're chasing a fleeing felon into a house. They don't have to stop at the threshold and go get a warrant. They can chase him in there. And when they seize him inside of his own house, then it's not going to violate the Fourth Amendment. They can seize evidence without a warrant if it's likely to disappear, things like scrapings of tissues from under a suspect's fingernails that'll get washed away. In the Missouri versus McNeely case from just last year, the police determined whether or not they could, what they could do with regard to blood alcohol testing. And just because blood alcohol tends to dissipate, it does dissipate over time, doesn't automatically constitute a sufficient exigency to justify a warrantless blood alcohol content test. As in the case of any evanescent evidence, a determination whether a warrantless test is reasonable depends on the totality of the circumstances. If they can reasonably obtain a warrant before a blood sample is drawn without significantly undermining the efficacy of the search, the Fourth Amendment requires it. In general, establishing probable cause is simple in drunk driving cases, and warrants can be obtained quickly by telephone, email, or video conferencing. Thus, warrantless blood alcohol testing is often going to be unreasonable. So if you get pulled over, can the cops hold you down and take some blood from you? while you're kicking and screaming on the side of the road? The answer is here, no, right? Because they can't just say, well, you know, every second we were waiting, his liver was just destroying the evidence. That's not good enough under the McNeely case. They do have time to get a warrant. Now, if they get a warrant from a neutral and detached magistrate, then they can hold you down and take out the blood. Emergency aid exceptions. Emergencies that threaten health or safety, if not immediately acted upon, will justify a warrantless search. So if they think that you're having a heart attack in your house and they rush in to grab you to take you to the hospital and see bales of marijuana in your house, then they didn't need a warrant to enter, because they entered to render emergency assistance, not to search for evidence. And again, you know, that's really where the starting point for that analysis is. Why are the police going in the house? Is it to search for evidence? To find a crook, is what we always talk about in my criminal procedure class. Are they looking for a crook, or are they looking to help somebody who's in an emergency situation? And that's the key. Another exception to the warrant requirement, administrative inspections and searches. If police or building inspectors or food inspectors want to check to make sure something is not going to harm the public, can they just come into your house and start looking for rotting beams and stuff? Well, the answer is not exactly. Inspectors have to have a warrant for searches of private residences and commercial buildings. However, the standard for whether there's probable cause to search is a little different. If there's a general and neutral enforcement plan that justifies the issuance of the warrant, then the police can go search there. If they're looking for contaminated food in a restaurant, they don't need a warrant at all for that. And they don't need a warrant if they're going to search in a highly regulated industry like a auto wrecking yard or a gun shop, something like that. All right, inventory searches. This is often tested. I'd put a little star next to this. And it's simple. If you get arrested for whatever reason, suppose you get arrested because they think that you committed mail fraud in in some sort of Ponzi scheme. So when they happen to arrest you, you happen to be driving a car. They don't have probable cause to believe that you're going to have anything in your car. So they take your car, they don't want to leave it on the side of the road, so they have it towed to the pound. At that point, can they search your car? Well, not pursuant to the automobile exception, because there's no probable cause to believe that you have any evidence in that. They'll find any evidence in the car. But can they search it? Can they take an inventory? Yes. And that's what this is all about. Why are they digging through your car? Are they looking for evidence? No. No, they're not trying to catch a crook. They're just trying to do an inventory. So they're trying to be your friend. So they can make sure that they get you back all of your property when they give you your car back. That's the rationale here, right? It's really an administrative matter. They're not, again, looking for a crook, looking for evidence. They're looking to help you. And if they happen to find the bales of marijuana or the body in the trunk, then they can use it against you, even though they seized it without probable cause and without a warrant. They found and seized it without probable cause or a warrant. It's really that simple. Airline passengers, we all know that we are subject to the colonoscopies at the airport. Public school searches. This happens every now and again on the bar. And students have a lesser expectation of privacy. They know that teachers can search their, sometimes they have to go to school with see-through backpacks, and teachers are there really to help them. They're minors, so they have a diminished expectation of privacy, but they still have some rights, and that's what the New Jersey versus TLO case is all about from 1985. The police need some justification, and school officials at public schools, and of course this doesn't apply if you went to private school, but they need reasonable grounds to search a locker. They can't just have a search for no reason. But it's not probable cause or even reasonable suspicion, it's something less. When does it exist? If there's some moderate chance of finding evidence and the measures are reasonably related to the objectives of the search and it's not excessively intrusive in light of the age and sex of the student, etc. So let's see what else. Okay, what about extracurricular activities? Can they force you to submit to random urinalysis? And the answer to that is yes. Parolees. This was tested once. If you're on parole, you have a lesser expectation of privacy, and if the police, if a condition of parole is that the police can randomly search your house, then the Fourth Amendment is not going to require the police to have a warrant or even probable cause because of that diminished expectation of privacy and also the heightened need to search you because you're a known felon. Government employees' desks and files. This was tested. This has been tested twice recently. So this is important. Now again, this is a government employee's desk. This doesn't apply if you work at Best Buy. A warrantless search of a government employee's desk and files is permissible under the Fourth Amendment if it is reasonable in scope and it is justified at its inception by a non-investigatory, again, they're not looking for a crook, non-investigatory work-related need or a reasonable suspicion of work-related misconduct. Drug testing is allowed. Mandatory drug testing is allowed if there's some special need, like for example, you're flying an airplane or driving a train. The government can require you to, put your arm out or give them a urine sample. However, they can't do it just to catch a crook, or if there's no special need for it. Searches in foreign countries and at the border. I'm going to skip over that. Again, just know, and all you need to do, if you see anything to do with a border search, just say people at borders, whether the border is the geographic border or a functional border like the Atlanta airport, if a flight comes in from Colombia, you have a lesser expectation of privacy, and the government has an enhanced need to interdict contraband. So because of your diminished expectation of privacy at the border or its functional equivalent there in Atlanta, and the enhanced need to interdict contraband, then the Fourth Amendment doesn't require warrants for those sorts of searches. Don't even require reasonable suspicion or probable cause either. All right, that's all I'll say about that. Next page, 30, wiretapping and eavesdropping. Never been tested. Again, you just need a warrant for those sorts of things. Bottom of page 31. Methods of obtaining evidence that shock the conscience. Sometimes, even if you get a warrant, suppose the police said, yeah, we suspect that the police suspect that you, for example, have stolen some bubble gum in violation of theft laws from a convenience store. And they seize you as you come out of the convenience store while you're smacking away. And then all of a sudden, as soon as you see the cops, you stop smacking. And they say, son, did you swallow that gum? And you go, what gum? Did you swallow that gum? What gum? They have probable cause to believe that you stole a piece of gum and that you swallowed it. So they go to a neutral and detached magistrate. They have probable cause to believe that the evidence will be found in your stomach, and they get a warrant to have you cut open to get the evidence. Well, you would think the Fourth Amendment would allow that, but it doesn't. The Fourth and 14th Amendment do not allow methods of collecting evidence that shock the conscience. So due process of law and the Fourth Amendment both, if there's an intrusion into the human body, the Fourth Amendment's going to apply. Merely taking a blood test doesn't shock the conscience. After all, just a little needle going into your arm. It's not like a scalpel or an endoscope going into your stomach. Surgery, obviously that's bad. If a crime, so just leave it at that. Even if the police sometimes have a warrant and probable cause, that doesn't mean that they can do, that the Constitution allows any kind of search. There is this 14th Amendment due process or Fifth Amendment due process, if you're talking about the federal government, notion that some intrusions are so heinous that they shock the conscience and are unreasonable under the Fourth Amendment or violative of due process under the Fifth or 14th. Okay, let's stop there for right now, take our break for 10 minutes, and then we'll come back, and then we'll take the second most important thing that you need to know from constitutional criminal procedure, namely confessions. Okay, let's go ahead and resume for our last segment of the day. Confessions. Confessions are, as I've already mentioned, the second most tested area of constitutional criminal procedure on the Louisiana test. Usually, there's going to be at least one, or more often than not, two questions that deal with confession law. And by confession law, I mean usually Miranda, the requirement that the police read you your Miranda rights prior to custodial interrogation. And so that's what you typically see. So we'll start here with confessions and see where it takes us. Okay, confession law is not just like the search and seizure law, which is all essentially under the Fourth Amendment and 14th Amendment. Confession law is this fabric of Fourth, Fifth, Sixth, and 14th Amendment principles. Let's first start with the 14th Amendment and voluntariness. Now, this is fairly simple. Under the 14th Amendment, and the 14th Amendment due process clause, we just finished our discussion of how the due process clause prohibits searches that shock the conscience. The 14th Amendment due process clause is fairly indeterminate, and you remember that from substantial notions of justice and whatnot from International Shoe from your first semester. And here it is again. If a confession is given in a way that is involuntary, that is, it's beat out of you, it is threatened or coerced out of you, then it's going to offend due process. And it's really that simple. For confessions to be admissible, the due process clause requires that they be voluntary. How do you determine if something's voluntary? You look at the totality of the circumstances. All of the circumstances, the setting, how long it took, the manner of interrogation. Obviously, if it was obtained by physically beating a defendant, it's going to be involuntary. It could be involuntary without physical threats or violence if it, again, in the totality of the circumstances, it is coercive. There's got to be official compulsion. It can't be involuntary because the Martians told you to confess. It's got to be the police doing it. And you think that this really wouldn't happen anymore. I actually had a case at Tulane and Broad in Orleans Parish where the police were talking to a suspect and asking him if he committed a crime. On tape, they thought they turned the tape off, but they didn't turn the tape off, and the police officers are hearing, you hear this little clink, 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 clink. And what they did is they pulled out a pair of pliers and they told him they're going to pull his balls off unless he told them what happened. And he told them. And that was suppressed because it was involuntary. Sixth Amendment right to counsel. This is our first discussion of the Sixth Amendment. And you don't see the Sixth Amendment being used that often in motions to suppress confessions, but you do it at times. What is the Sixth Amendment right to counsel? Well, you have, if you are being prosecuted, a right to counsel after formal judicial proceedings have commenced against you. That is, after they've taken you to your initial appearance before a magistrate. At that point, you're in the court system. Once you're in the court system, you're not just under arrest at the station house. You have started the judicial process by being in court. Once adversary judicial proceedings have commenced against you, you have a right to a lawyer. Again, assuming it's a felony prosecution, etc. You have a right to a lawyer. So what does that mean? Well, it means they've got to give you a lawyer, and nothing important in the case can happen unless you have your lawyer with you. And it's really it's that simple. You have a right, once those adversarial judicial proceedings have commenced against you, to have a lawyer with you at every critical stage of the proceeding. Well, and we'll talk later in the outline about how that means at your trial, Gideon versus Wainwright, at your trial you have a right to a lawyer. But for our purposes, we're talking about confessions. So under the Sixth Amendment, you have a right to have a lawyer with you if you are being questioned by the authorities after formal judicial proceedings have commenced. So once you have been, let's say you're under indictment and you're in jail, the police just can't show up and start asking you questions. Even if they read you your Miranda rights, they can't show up and start asking you questions. Why? Because you have a right to have your lawyer present. This is a critical stage now. So at any time after, we're not going to talk about all this stuff at the bottom of page 33 and the top of page 34. We're going to talk about that later when we're talking about the Sixth Amendment right to counsel in general. Right now we're just talking about the Sixth Amendment right to a lawyer at an interrogation or questioning by police, and that is all this other stuff doesn't really fit there. Okay, top of page 35. This is the Sixth Amendment is offense specific. So suppose you have been indicted for murder and you're in jail. The police can't come and ask you about that murder unless they invite your lawyer to come along, because that's a critical stage. But suppose they want to ask you about the kidnapping of the little girl. Can they ask you about that? Yes, because you have no right to counsel, at least Sixth Amendment counsel, for that purpose. They got to comply with Miranda and whatnot, more on Miranda in a second. But under the Sixth Amendment, they can ask you about this other crime because you have not been indicted as to that other crime. So that's what the outline means by offense specific. So how does this usually come up? And how is it tested? I had a case in federal court, a federal death penalty case that resolved just a year or two ago, where my client's in jail and he starts talking to his roommate, Jumbo. Jumbo starts talking to him about his crime. My guy had killed a deputy sheriff in a bank robbery. And Jumbo then calls the FBI and tells the FBI, hey, look, man, he's talking about the crime. He's talking about the crime. And the FBI agents say, get as much information from him as you can. Well, Jumbo goes back into the jail cell and starts pumping him for information and taking notes. Lots of notes about what my client's telling him about the bank robbery and killing the deputy. Well, we get the notes, and they're going to call Jumbo at trial, so we move to suppress any statements taken from him by Jumbo. Well, is Jumbo a governmental actor? Yes, he's put up to it by the FBI. The FBI told him to take good notes. And he was under indictment, right? So he had a right to have me there with him while Jumbo was pumping him for information. And Jumbo never invited me, nor did the FBI. So the judge suppressed all of the stuff that Jumbo was going to say my client said. Why? Because the Sixth Amendment guaranteed my client a right to a lawyer for that critical stage, the post-indictment questioning by the authorities. Now, this right can be waived. The waiver's got to be knowing and voluntary. And again, usually if the defendant waives it after getting Miranda warnings, then it may be enough. But the simple fact of the matter is it can be waived. What's the remedy? Well, obviously, if what we're talking about is just a confession, the remedy is going to be the confession is going to be suppressed. Impeachment, a statement obtained in violation of defendant's Sixth Amendment right to counsel, while not admissible in the prosecution's case in chief, can be used to impeach the defendant's contrary trial testimony, which meant that was still a problem for me. Even though Jumbo could not testify in the government's case in chief, if my client took the stand and said that he was very sorry about, during the penalty phase, and said he was very sorry about killing the deputy, they could still call Jumbo, and Jumbo could say, he told me he wasn't sorry. He told me he was glad he shot the deputy. That's what he told Jumbo. So we still had the problem that even though the government couldn't put Jumbo on during their case in chief, they could still call him to impeach my client's contrary testimony. So that is a limitation on that suppression. Now, of course, I was delighted a couple of months later to see Jumbo in the obituaries. Jumbo died of a heart attack. He was real fat, and he died of a heart attack. So he was never able to come testify one way or the other. Fifth Amendment privilege against Miranda. Okay, so what we just talked about is the Sixth Amendment right to counsel. Now we're going to talk about the Fifth Amendment right to counsel under Miranda. And we all know, of course, because we all watch TV, that if you are under arrest and in custody, that before the police can interrogate you, they have to read you your Miranda warnings. And the thinking here, of course, is that custodial interrogations are so inherently coercive that we want to level the playing field a bit between the police and the arrestee. So the police have to tell the arrestee that you don't have to talk to us. And after the police tell him that and these other warnings, then if the guy decides to talk, then it's going to be with his eyes wide open. Okay, so what are the warnings? And how is this tested, first of all? Well, sometimes it couldn't be simpler on the exam. The police just start questioning somebody in custody without reading him his rights. This happened on the February exam. The police had somebody under arrest. They asked him a bunch of questions. He confessed to the crime. Then they read him his rights, and he confessed again. So that's as simple an application of Miranda as there possibly could be, where the police just don't read the suspect his Miranda rights before questioning him in custody. What rights do they have to read him? Well, these. You have the right to remain silent. Anything you say can be used against you in court. You have the right to a presence of a lawyer, and if you can't afford a lawyer, one will be appointed if you want that. So the Fifth Amendment requires this. These warnings don't have to be verbatim. They just have to, in substance, advise the arrestee of all of those rights. When is it required? When are these warnings required to be given? Anyone who is in police custody and accused of a crime, no matter what crime, must be Mirandized prior to interrogation. That simple. All right, Miranda only applies to investigations by the police. Again, mall cops can ask you all the questions they want. Miranda warnings need not be given before questioning by a cellmate covertly working for the police. Okay, so for example, suppose Jumbo was in jail with my client before my client was indicted, before the commencement of formal judicial proceedings, and therefore my client had no Sixth Amendment right to a lawyer at that point. So no Sixth Amendment issues. Can Jumbo then work for the police and pump him for information? Well, the answer there is yes. Why? Because even though he's in custody, he's in jail, and he's being interrogated in jail, and even though the interrogation is by a government agent, Jumbo, there is not that coercive environment. It's not a true custodial interrogation because the defendant, arrestee, does not know that he's being interrogated by the police. He thinks he's just talking to his cellmate. Next page, custody. Miranda only applies if you are in custody. What is custody? Well, we all know arrest is custody. We all know that. So we're not going to talk anymore about that. If you're under arrest, you're in custody. But what about if you are being detained under circumstances that are fall short of arrest? And that's what we're dealing with here. And here, it's again a totality of the circumstances test. You have to look to see whether the suspect was free to terminate the interrogation and walk away. Here's the key. If an individual's freedom of movement was curtailed in a way similar to arrest, then you consider whether or not the relevant environment presents the same inherently coercive pressures as the type of station house questioning at issue in Miranda. So it's really all about whether these coercive pressures exist. Therefore, the more a setting resembles a traditional arrest, the more likely the court will consider it custody. If the detention is voluntary, it's not custody. If the detention is long and involuntary, it's likely to be custody. This is an objective test. Again, considers the totality of the circumstances. All right, traffic stops. And I remember when this case, Berkemer, came out, I found it to be quite interesting. And then this is the issue. You get pulled over by the police. We all know the Fourth Amendment requires that the police have some justification for pulling you over, either probable cause, reasonable suspicion, or it's a traffic stop, a checkpoint kind of thing. But suppose you get pulled over, and there is a Fourth Amendment justification for pulling you over because the police officer, because you got a burned out rear tail light. And the cop says to you, hey, what are you doing driving around here? You up to no good? And you hang your head and you say, yeah, I just killed 4 people. Well, that was an interrogation, right? The cop asked you, what have you been doing? Are you up to no good? And you confessed. And you have been stopped by the police. You're not under arrest, but you're in a detained situation such that the Fourth Amendment requires reasonable suspicion of probable cause or some justification, right? Question, are you in custody for purposes of Miranda, the Fifth Amendment? We're not talking about the Fourth Amendment now, we're talking about the Fifth Amendment. Well, the answer is no. Although a routine traffic stop curtails a motorist's freedom of movement, such that the Fourth Amendment applies to it, such stops are presumptively temporary and brief, and you know that you're going to soon be on your way. Therefore, it's not that same kind of custodial, coercive, pressured environment like Miranda. Incarcerated suspects, just like we've talked about, the fact that you're incarcerated doesn't automatically mean that any interrogation is custodial. It still turns on whether the person's freedom of action is limited in a significant way. The interrogation requirement refers only to questioning by a known police officer that are reasonably likely to elicit an incriminating response. So, for example, suppose you're in custody, and when you're in custody, you spontaneously blurt out, I killed my girlfriend. Well, that wasn't in response to an interrogation. You just blurted that out. That was spontaneous. The fact that the police hadn't read you your Miranda rights is really is irrelevant. Miranda also doesn't apply to routine booking questions like what's your name, where do you live. If the police are talking to each other about, boy, we sure hope we find that gun so a little girl doesn't kill herself, that's the Innis case. As long as that's not going to, even though the police might be hoping to get the guy to overhear it and confess, that's not going to be a, quote, interrogation unless the police are aware that the suspect was peculiarly susceptible to an appeal to his conscience. Right to waive or terminate an interrogation. Okay, so assuming that you are in custody, that you are being interrogated by a state actor, you have a right to be read your Miranda warnings before being questioned. But you also can waive them. After you get your rights, you could say, okay, I hear you, but I want to talk anyway. And that's what this is all about. So what can happen after you've gotten your rights? Well, one is you can just sit there and do nothing. One is you can expressly waive your rights by saying, okay, I waive my Miranda rights, I'm ready to talk. Or you can say, I want a lawyer and I want to remain silent. Okay, so nothing, waiver, assertion. Those are the possibilities. Okay. If you don't respond at all, is that going to be considered a waiver? Well, again, it's totality of the circumstances. If you are just sitting there and you don't waive or assert your rights, the police can still just sit there and continue to question you. And if you start talking, it may be that under the totality of the circumstances that you have waived your rights. Again, it just depends. If you say, oh, okay, I'll talk to you all, well, that could be a waiver. Waiving rights. The detainee may waive his rights under Miranda to be valid. The waiver's got to be knowing and voluntary. You got to look at all the circumstances to determine whether the waiver was knowing and voluntary. A detainee who's received Miranda warnings and then chooses to answer, that's probably enough. You don't have to expressly say, I waive. You can just start talking after you've gotten your rights, and that can be enough, perhaps, to constitute a waiver under the totality of the circumstances. Now, keep in mind that the right to remain, the Miranda right, what you have the right to do after getting your rights, really is twofold. You have the right to say nothing, just to remain silent, but you also have this right to counsel. So which right you assert matters sometimes. And let's look at it. First of all, if at any time prior to or during questioning you've had enough, you don't want to talk, you don't want to talk anymore, and you just want to remain silent, you can, as long as you do it explicitly, unambiguously, and unequivocally, say, I want to keep my mouth shut. I want to remain silent. At that point, the police must scrupulously honor, that's a little buzz term you need to remember. The police must scrupulously honor your invocation of your right to remain silent and stop asking you questions. Now the question becomes, can they reinitiate interrogation? This is the way it always comes up on the bar and comes up in the field. Well, that all turns on whether the police have scrupulously honored your invocation. If after you invoke your rights, they say, okay, darn, all right, and they leave. Then they come back 5 minutes later. Hey, want to talk to us? No, I don't want to talk to you. Okay, darn, all right. 5 minutes later. Hey, you want to talk? That's not scrupulously honoring it under the totality of the circumstances. But suppose they leave for 2 or 3 days, and then they come back because they found a new dead girl. And they say, hey, look, we just found this new dead girl. You know anything about her? Yeah, killed her. And the other one you asked me about yesterday. Well, under that may be okay. Why? Because they did scrupulously honor his invocation at first, and they've come back and they're asking about a different crime. It would be even better if they had re-Mirandized him. Again, it depends on all the circumstances, but all you need to know is that the standard is whether they have scrupulously honored. And some of the factors in this Mosley case, from old case, is whether they've rewarned you, whether they're talking about a different crime or the same crime. Again, it's all just a kind of one of those totality of circumstances mushes. Right to counsel. All right, suppose instead of just saying you want to remain silent, what you say is, I want to talk to a lawyer before I talk to you. Well, at that point, again, all questioning has got to stop, and they cannot, and this is a prophylactic rule, they cannot resume questioning about any crime at all. Why? Because the right, invoking that right to counsel is an invocation of a higher order than just the right to remain silent. The police may not even question the detainee about a totally unrelated crime. All questioning must cease. Now, suppose you're sitting in jail and they've stopped questioning you and you say, hey, I've changed my mind. I want to talk. Well, at that point, as long as you, the detainee, reinitiates or starts the conversation, then if you've initiated a resumption of questioning, then that's okay. They can talk to you then. Now, all this stuff about the Fifth Amendment rights of counsel under Miranda applies whenever there is custodial interrogation. Yeah, we know that. Why did they just stick that in that middle of the outline? I don't know. But there it is again. It's just kind of, there it is. Compare the Sixth Amendment right to counsel is offense-specific. Remember, we've already talked about this. If you are under indictment for murder, they can talk to you about a kidnapping. Because you don't have a lawyer for the kidnapping yet. The Fifth Amendment Miranda right is custody-specific. If they've stopped asking you about, if you've invoked your right to questioning about the murder, they can't just reinitiate questioning about an unrelated crime. Now, that's something that is going to be factored into an evaluation of whether they've scrupulously honored your right to remain silent, but under your invocation of your right to Miranda counsel under the Fifth Amendment, they can't even talk to you about a different crime. Your invocation of your right to counsel has got to be unambiguous and specific. If you say something like, yeah, I'm thinking about a lawyer, maybe I've seen some of those guys on TV, maybe I might want one. That's is ambiguous. That's not an invocation. Once you have invoked your right, next page, you invoke your right to counsel, then the lawyer has got to be present with you. It's not enough that you've had an opportunity to go talk to a lawyer and then the cops show up when he's gone. Duration of the prohibition. The prohibition against questioning a detainee after he requests a lawyer lasts the entire time that the detainee is in custody for interrogation purposes, plus 14 more days after he returns to his normal life. When this case came out, this Schatzer case, I found it interesting. I mean, you can see the point. The point is, you're in jail, right? The police come to you, and they say, hey, you want to talk to us about this murder? And you go, no, I want to talk to a lawyer. Okay, all right. They can't ask you any more questions at that point. So now what they do is they say, they go out in the hall and they talk and they go, let's let him go. We don't really have any evidence. We think he committed the murder. We don't have any evidence. So let's just let him go. So they unlock the jail and they say, okay, you're free to go. And they walk outside of jail. And then after that, they come out and say, hey, now that you're out of custody, you want to talk to us about the murder? You want to talk to us about the murder? Why don't you tell us about the murder? Why don't you tell us about the murder? The point of this case is that after you request the lawyer, the whole time that you're in custody, they've got to respect that right? Plus 14 days after the detainee returns to your normal life. After that point, the detainee can be questioned regarding the same matter upon which receives a fresh set of Miranda warnings. So it's just odd. Where in the Fifth Amendment do you find this 14 days? How did the founders come up with that? How did they come up with the 14 days? Well, yeah, 14 days. That's a good period of time. I mean, sometimes people just pull this stuff out of their bodies. 14 days. All right. Statements obtained in violation may be used to impeach. Now, again, if you are unmirandized, you confess to the crime, state can't use that confession in its case in chief. But if you testify that you didn't commit any crime, the state can still impeach you with your unmirandized statement. And that's kind of an important limitation on that Miranda right. Now, if it was given, if the police beat a statement out of you and it was involuntary, That can't be used in the state's case in chief or to impeach your trial testimony. Effect of a violation, oh, I think we've just done this. Use of confession for impeachment. A confession attained in violation of the defendant's Miranda rights, but otherwise voluntary, may be used to impeach the defendant's testimony. If he takes a stand at trial, yeah, we've already said that. The prosecutor may not use the defendant's silence after receiving Miranda warnings to counter the defendant's insanity defense. Warnings after questioning and confession. This has always been the sneaky thing, right? Suppose, and this is the question first, warn later issue. Suppose you're in custody. When you're in custody, the police are, they're your friends. They're giving you Cheetos and coffee, talking about how that little girl was a really bad girl. She needed to be killed. Glad somebody killed her. You're going to be a hero for killing her. Here, have some Cheetos. Want a Coke? Right? And then your friend, right? They're your friend. And all of a sudden you start saying, while you're crunching your Cheetos, yeah, I'm glad I killed her too, and she deserves to be killed. And then all of a sudden they reach over to the recorder and they start the recorder and they say, you have the right to remain silent. Anything you say can and will be used against you in a court of law. Now we have some questions about the death of a little girl. Do you know anything about a little girl that was brutally killed? And you're eating your Cheetos, and you're wondering, well, who are these people? What happened to my friends? Now they have Mirandized you, and they've got the recorder running, and then you say, well, of course the cat's out of the bag. He's running around the interrogation room. So all you say is, yeah, of course I killed her. We just told you that last hour. Is that a permissible technique? And that's what the court... And that was written in some police manuals. How about that? Court takes that up in Siebert in 2004. And what does the court say? Well, if the police obtain a confession without Miranda warnings and then give Miranda warnings and then get him to confess again post-warnings, that is going to be inadmissible if they intentionally try to circumvent his Miranda rights through that little cat-out-of-the-bag trick. If, however, the original unwarned questioning was unplanned and it was inadvertent that they didn't give him his Miranda warnings, and they go, oh, we forgot to give him his Miranda warnings. Let's now give him his Miranda warnings. Then the subsequent confession is going to be admissible. Now, the first one, pre-Miranda, is never going to be admissible, but the subsequent one will be admissible. It's all just a matter of whether they are intentionally trying to circumvent the Miranda rights. Non-testimonial fruits. Suppose you say, no Miranda warnings. You say, yes, I killed a little girl, and then I put her head in a dumpster behind the Best Buy. And they go and they find her head and they want to use that in evidence. So the question becomes, can they use that evidence? They learned about it from an unmirandized confession. That's what this is all about. And the answer is yes, more than likely. In the plurality opinion in Patain, the court said that the evidence is going to be suppressed if the failure was purposeful, but if the failure was not purposeful, then the police, then that evidence can be used. Right? This confession can't be used, but the stuff that they found through the confession probably can be used. Public safety exception. If the police, you're in custody, and the police are interrogating you, but they're interrogating you not because they want to catch a crook, but because they want to make the world a safer place, those statements are not going to be suppressed because of the public safety exception from quarrels. So, you're under arrest. The police said, hey, we're concerned that a gun that you may have used in a robbery is going to be used by a little girl to shoot herself. Do you know where that gun is? Oh, yeah, I don't want any little girls to be hurt. It's in the playground right now by the bank. And they go find it. Can they use your statement? Remember, they didn't read you your Miranda rights before they asked you where the gun was. The answer is yes, because there was prompted not by concerns about catching a crook. It was prompted by concerns about public safety. Okay, pretrial identification. This is the next most popular area of testing. We're really kind of just going down the steps, right? Most important is Fourth Amendment, searches and seizures. Second most important, confessions, and particularly Miranda. Third most important, pretrial identification. And what are we talking about by pretrial identification? Well, what we're talking about are lineups, live in-person lineups, where the police bring people and put them up on a stage, and they've got the heights behind them, and a witness comes into a little booth with one-way mirrors and glass on it and says, yes, it's the perpetrator number 2. That's a live lineup. Does that happen? No. Only it happens on TV. But it doesn't happen in real life ever anymore, right? That's one thing. The other live procedure is what's called a show-up, where just one person is presented to an eyewitness, and the question is put to the witness. Is this the guy who did it? Does that happen? Yeah, that happens. It happens if they catch a guy running away from the scene of the bank, they can bring him back in and say, is this the guy who just robbed you? And everybody says, yes, that's him. That's called a show-up. It's not a lineup because it's only one person. That's a live, sometimes called corporeal ID procedure. Does that happen? Yeah, spontaneously, every now and again, yes. The other kind, another kind, is the photo array. This is how 99% of visual identification procedures are now conducted. I made that 99% up. It could be 93.6. What it is the police get mugshots of 6 people, and they put them all on usually one 8.5 by 11 piece of paper, or it could be individual photographs, and they show the photographs to the witness, and they say, is the perpetrator among those depicted in these photographs? And then the witness says, yeah, it's number 3, and points to somebody. That's a photo array. It's a pretrial identification procedure. Now, then there are also, could be voice identification procedures where they tape the voice of somebody saying, give me your wallet, and then they'll play it to the robbery victim. Does that sound like him? Yeah, that sounds like him. So what we're talking about here are pretrial identification procedures. By and large, what we're talking about is visual identification, and usually then photo arrays. But it also could be other identification of a smell. Does this smell like the perpetrator? Does it sound like the perpetrator? Does this feel like the perpetrator? So again, it could be anything else. So assuming, now that you understand kind of what we're talking about, let's talk about the constitutional limitations on these procedures. And the first constitutional limitation is back to our friend, the Sixth Amendment right to counsel. If the police are going to do a live lineup or a show-up, that's a pretty important day in your life as a criminal. Pretty important day. That's a critical event. So if that little circus is going to be orchestrated and it's going to happen, then your lawyer gets to come with you if you're under indictment, if formal judicial proceedings have occurred. And that's all this is. We know that if you're not yet in the formal judicial process, you don't have a Sixth Amendment right to a lawyer for any purpose, much less for pretrial identification procedures or for interrogations, etc. But assuming you have a right to a lawyer because formal judicial proceedings have commenced, let's talk about this. All right. So when does the right exist? Well, again, post-charge lineup or show-up. That is, it's got to be a corporeal procedure. You don't have this right if the police are conducting a photo array with a witness back at the station. So it's got to be a corporeal, your body. You have to be there in person. That is, it's got to be either a lineup or a show-up live, and it's got to be after the commencement of formal judicial proceedings. Then, if it's conducted without your lawyer being present, then it's going to be suppressed. What's the role of your lawyer? Your lawyer doesn't have any role. He just gets to come and watch. That's really all. You don't have a right to counsel at photo identification procedures, as we've already said. And you don't have a right to counsel if the police are taking physical evidence, like handwriting exemplars or fingerprints from you. Okay. That's due process. I mean, excuse me, that's Sixth Amendment. How often do you see this on the bar? Never, even once. How often do you see that in practice? Never. Why? Because the police just don't do corporeal lineups anymore, particularly after the commencement of formal judicial proceedings. And they don't do show-ups either, right? The show-ups are usually done right after the crime has occurred, and they take the guy back and say, is this him? Not after charges have been brought. So you never see the Sixth Amendment being implicated by lineup procedures. But theoretically it could be, and that law exists, and there it is on page 44. What happens, and where all the stuff is usually going on in real life and on in the bar, is here under the due process standard. What limitations does due process impose? Well, this is the potential problem. We don't want the DA using evidence that is unreliable. So suppose that the witness says that the perpetrator was a 7'1" Caucasian male. Well, who do they arrest for the crime? A 7'1" Caucasian male. And then they put him in a lineup next to 5'3" Asian females. Well, how's that identification procedure going to go? Can you see the perpetrator in the lineup here? Yeah, you know, I think it's the tall white guy. Right? That's unfair. That's unfair. Due process is implicated by that kind of procedure. Now, that's an extreme example, but suppose that the only photograph in the array, and I've had this case before, the only photograph in the array is a guy in an orange jumpsuit. Everybody else has a tie on. Well, that's pretty bad, right? What about this one? Suppose they've got the lineup, right? And I had this. My client was accused of robbing a sandwich artist at Subway, and what they did is they go to Subway with the photo array, and they give it to the sandwich artist, and they say, "Is number 3 the perpetrator?" Yeah, it was number 3. Well, then they said, look at him real good so you can remember at trial. Got it. All right. So the question is when does due process call for the suppression of the results of those kind of procedures? Okay, here we go. A defendant can attack an identification as denying due process when the identification is unnecessarily suggestive and you got to circle that and, circle it a couple of times, and there is a substantial likelihood of misidentification. That's the standard. It's simple. So what do you have to show if you're trying to suppress? And remember what you're trying to suppress. You're trying to suppress the police officer coming to trial and saying, I showed the witness these photographs, and she picked out number 3. Who is the defendant? That's the testimony you're trying to suppress. You're also trying to suppress the witness coming to court at the trial and saying, the police officer showed me these photographs, and I picked out number 3. You're trying to suppress that because it was, first of all, unnecessarily suggestive. What does that mean? That is anything that the police may do that suggests that one of these people is the perpetrator. Now, the suggestion could be subtle, like only having one 7-foot-plus Caucasian in the lineup. That suggests that he is the guy, the right one to pick. It could be asking if number 3 is the perp. That suggests that that number 3 is the right one to pick. That's suggestive. So anything, having one guy in an orange jumpsuit suggests that he is the guy. So anything by gesture, by unfair selection, by question, that suggests that one of these people is the right one is unnecessarily suggestive, or can be, is suggestive. All right. It's also got to be unnecessarily suggestive. which means there are some procedures that are suggestive. Take the show up at the scene. The police take back to the bank a guy who's out of breath and is covered with red dye from the dye bomb. And they ask, as he's panting, is this the guy who just robbed the bank? And all the tellers say that's him. Is that a suggestive procedure? Yes, you bet it is suggestive. But it's not unnecessarily suggestive. One-on-one corporeal show-ups are, by all accounts, by every opinion, suggestive, but they're not unnecessarily suggestive if they're done shortly after the crime in an effort to identify the criminal right away. Okay? So, back to my sandwich artist thing. When they said, is it number 3, was it suggestive? Yes. Was it unnecessarily suggestive? Yes. There was no reason that they needed to do that weeks after, well, it was a couple of days after the crime. They didn't need, there was no necessity for pointing out number 3. Good, so I win, right? No, I don't win, I lose. And I lose, why? Because of the and. It's not enough just to establish that a procedure was suggestive and unnecessarily so. You also have to prove that there's a substantial likelihood that the witness just got it wrong. And in my case, they had him on the robber cam. I mean, they had all kinds of other stuff against him. So it was fairly obvious that he was the robber. And so there was not any likelihood that she got it wrong. So that's what kills most people on these motions to suppress. You can establish that they had an unfair picture of him, but they've got other evidence to show that there's no likelihood that a mistake was made. So for your purposes, you just need to make very clear to the examiners that you understand that it's got to be suggestive, unnecessarily so, and that a substantial likelihood of misidentification will arise. So again, some of these examples, I've already kind of talked about them already, so I'm not going to go over them again, but there you go. Okay, what's the remedy? Well, the remedy is we're going to exclude the testimony about what happened out of court when the police showed that array to the witness. But, and keep with me here, are we going to exclude that witness from being able to testify at trial that he is the perpetrator? Because remember, if we exclude testimony about what happened with the photo array, the next issue is, are we going to allow that witness to come and testify not about what happened when the police showed her the pictures, but that's the guy who robbed her? And that's what this is all about. The remedy for an unconstitutional identification procedure is exclusion of not only that evidence, but also of the subsequent in-court identification of the defendant as the perpetrator, unless it has an independent source. And that's all about whether or not the in-court identification will be tainted by the bad out-of-court procedure. And this is what this says. A witness may make an in-court identification despite the existence of an unconstitutional pretrial ID if the in-court identification has an independent source. And it's just a matter of looking at all the factors, etc. How long did the person have a chance to look at him at the crime? Now, like in my case with the subway case, it was going to be great because they told her to look at him, and that burned his face into her mind. So that would have been really good if there weren't other problems. But because then her ID in court would be tainted by the bad out-of-court procedure. No right to lineup. Defendants can't demand a lineup procedure. Yeah, that's okay. No self-incrimination issue. If they make you participate in a lineup, that doesn't involve at all the Fifth Amendment because it's not testimonial. More on that when we get tomorrow into the Fifth Amendment. But taking handwriting samples, blood, that doesn't violate your Fifth Amendment right. against self-incrimination. I'm not talking about Miranda. Your Fifth Amendment right against self-incrimination, because it's not an event where you're being forced to speak. You're just being forced to stand there. Okay, well, tomorrow we'll pick up on page 45 with our discussion of the exclusionary rule, and then finish tomorrow constitutional criminal procedure, and then move on and look at that test question.